The Institute.
Institute for Justice.
The National Law Firm for Liberty.
Hello and welcome to Short Circuit, your podcast on the Federal Courts of Appeals. I'm your host, John Ross, joined today by IJ attorneys Tatiana Pino and Josh House. Before we begin, a quick update from last week's show. You'll remember we talked about an IJ cert petition. Unfortunately, the court has decided not to hear that case, so our client, Mulata Salgado, who had $15,000 wrongfully seized from her, will not be getting her attorney's fees paid by the government. She will not be made whole. Josh, let's kick things off in the 8th Circuit in Sherwood, Arkansas. Do I have that pronounced right?
Yeah, the city of Sherwood, Arkansas. So this case, Williams versus the city of Sherwood, which, full disclosure, IJ took for the purposes of filing for rehearing in the 8th Circuit Court of Appeals. But the original decision came down and involved Tammy Williams, who wrote 4 bad checks for groceries in the late 90s. And this was just to pay for various household necessities for her family. And Sherwood prosecuted her in a city-run court for these bad checks. Actually, the city advertises to local businesses that it can prosecute bad checks very efficiently. And what happened was that after she was convicted, she had difficulty paying some of the fines and fees. And the city continued to pursue her for almost 20 years in order to recoup those fines and fees. In the process, it jailed her 8 times for being unable to pay. It showed up at her work 12 different times to ask her to pay money on the spot to satisfy her outstanding court debt. And eventually, Tammy was part of a class action. She was part of the class that was filed by, I believe, the ACLU in Arkansas. And the city of Sherwood settled, realizing the error of its ways, and changed the running of its hot check court, as they called it. But Tammy felt that this wasn't enough. She filed a suit for damages to cover for that 20 years the city pursued her and put her in jail for being unable to pay. And ultimately, the district court threw out her case. What's interesting is that the Court of Appeals didn't affirm the district court on the same holding. There was a complicated issue under the decision Heck versus Humphrey over whether or not Tammy should have filed a habeas petition essentially every time she was put into jail while they were pursuing her. But instead, the Court of Appeals avoided that decision, probably because there's a circuit split on it, and just said that she did not adequately allege that city officials and policymakers were the ones directing the city officials to put her in jail. And importantly, it said that the city municipal court could not be held liable or could not bind the city government under 1983, which was the federal statute that she was suing under. And that's a really astounding decision. It basically says that the city municipal court has free reign, at least as far as the city's concerned, to violate constitutional rights without the city being ultimately held liable for it.
Josh, tell me a little bit more about the fines and fees she faced. So she initially got a batch of fines in 1997 when she was found guilty for the hot checks. She never committed another crime over the course of 20 years. So was it just that initial set of fines and fees she could never pay off, or was it escalating each time she went to jail or had contact with the police?
Yeah, it was escalating each time. I think it was $300 each time would get added for the essentially a violation for failing to have paid prior fines and fees. And this is what, it's known as a cycle of debt kind of in the criminal justice literature that is formed when people have outstanding legal financial obligations. They can't pay, and then they're punished for their inability to pay. And at no point, I should say, throughout this process did Tammy ever receive a formal ability to pay determination where a neutral, detached judge looks and says, she's not paying even though she could pay, and therefore her refusal to pay is willful. There's an entire process that is mandated by the Supreme Court that a court must look into before you can put someone in jail for failure to pay. And that was not happening here. At least it's very important to note this case was dismissed in the lower court on a motion to dismiss. So this case was not even allowed to get to discovery. It's just the allegations, and the complaint alleged that she was not able to get an ability to pay hearing. She was extorted by police officers to pay or else be thrown in jail, which they did multiple times. So these were all things that the court had to accept as true. And because of the posture of the case, and yet didn't. It seems to just have ignored those allegations. So, IJ took this case for rehearing for two reasons. One, the decision that a municipal court could not be held liable for any of the acts it did, or at least a municipality could not be held liable for the acts that its municipal court did, is just, like I said before, really astounding. And even more so is the fact that the Arkansas Supreme Court actually issued a decision just 4 days before the panel opinion in this case, saying that the acts of a municipal court, if it was run by the city, can be imputed to the municipality. The reason this is complicated is that actually Arkansas is currently reorganizing its courts to become state courts, its municipal courts. They're becoming state courts. But many have not finished the reorganization process. And that's the situation that Sherwoods was in, was that it had not been reorganized as a state court yet. And the Arkansas Supreme Court, which gets the final word on these issues of state law and whether something's a state actor or a city actor, it said that if the court has not been reorganized as a state court yet, it is a city court, and the city can be held liable for constitutional torts that the court commits. IJ filed a petition for rehearing on that, and then the second reason was simply that the court seemed to ignore all of the allegations about the police department, which police officers are employees of the city and are acting pursuant to city policy. The court just seemed to ignore the role that the police had in Tammy's unfortunate situation, and then unfortunately, just a few weeks ago now, the Eighth Circuit denied rehearing on that petition without any opinion, without any reasoning, and that's a huge surprise. There's actually on-point Supreme Court precedent saying that if a state Supreme Court decision comes down during the pendency of a federal court of appeals decision, and that decision, that state court decision, is on a determinative issue of state law, that the Circuit Court of Appeals has a duty to reconsider its earlier decision, or at least to reconsider or rehear the case. The fact that the Eighth Circuit didn't do that is just it's a huge surprise, and it's in clear violation of Supreme Court precedent.
So, Josh, can I ask you a question about that? Well, on that ground, do you think that this is something that the Supreme Court should kind of slap down the Eighth Circuit for? Or, do you think that that's something that is going to happen in this case looking forward?
If this case is going to be petitioned for certiorari, it would definitely be a candidate for what the court sometimes does. It's called a grant, vacate, and remand, or a summary reversal. This would be just clear error correction at this point, because the Supreme Court has very clearly stated that these cases should be reheard. And the fact that this wasn't, it's in blatant violation of Supreme Court precedent. And when that's the case, the Supreme Court will occasionally issue just a quick short opinion, remanding it down to the Court of Appeals.
So what's the upshot of the decision, the original decision as it stands now? Does the Eighth Circuit say, oh, sorry, like you needed to have sued the state in this instance, and here's how you do that? Can you refile your allegations, or is it just done if the Supreme Court doesn't step in at this point?
Well, I think at this point, Tammy's case, which was filed by an attorney in Arkansas, would have to be, she would have to file it against a state actor. Although the reason that that's not really possible is that state judges have judicial immunity. And this would be a very difficult situation for her to allege, to get over the immunity doctrines in order to allege that her constitutional rights were violated. The reason for that, of course, is that if a judge violates your constitutional rights in a decision, the correct way to get that undone is normally through an appeal. And so the Eighth Circuit deciding that there was no policymaker involved here, or no city policymaker at least, and that to the extent anyone violated her rights, it was this state judge or so-called state judge, then really her only way to get relief in this case would be to file an appeal. Would have been to file an appeal back when the state judge was violating her rights, and because she didn't do that, it seems like she'd be out of luck. So I think at this point there's not really a clear way forward under Tammy's current legal theories for her to get relief for those 20 years of harassment.
Okay, and with that, let's move on to the next case, which comes out of the Sixth Circuit. Tatiana?
Yes, this case is called the U.S. v. Jones. It's out of the Sixth Circuit, and it was decided last month, March 2020. The author was Judge Sutton, and it was a unanimous panel decision, and it was on appeal from the U.S. District Court of the Western District of Kentucky. And the case deals with the scope of the Fourth Amendment in the context of a Terry stop, when the police want to stop and ask you questions about a misdemeanor that has already been completed. But before I dig into the legal analysis, I want to give you a little bit of an idea of what happened in this case and the facts. So this incident, it was a domestic violence incident that happened in April 2017 between a woman and her ex-boyfriend, who's the defendant, named Jermaine Jones. The allegations are that he appeared at her house unwanted, and they got into a fight, and things got out of hand, and he poured dish detergent on her couch and chased her out of the house, throwing Sprite cans at her, and that missed her. But he was able to throw a bottle of detergent at her and hit her on the back. So she flees, and then she comes back shortly after and sees him getting picked up in a white Tahoe-like SUV, is how she describes it. The police eventually arrive the same day or the same evening, and the officer finds evidence consistent with her account. He finds that the dish detergent on the couch, Sprite cans on the lawn, and a bottle of detergent on the lawn. While she's explaining the story, she tells the officer that Jones had threatened to kill her in the past. He could easily get a gun, and that she feared that he would probably come back to attack her once the cops left. Interestingly, as the cop is filling out his paperwork in the driveway, he notices a white SUV, a white Chevy Suburban, parked in the intersection by her home. And so he approaches the car and pulls over the car and IDs the passenger as Jones. And then he proceeds to arrest him for fourth-degree assault, which is a misdemeanor in Kentucky. I should also note that when he did ask Jones questions about the assault, and Jones denied them, but the officer just did not believe him and arrested him. Then the officer patted him down twice. Nothing came out of that pat down, but then later, when he goes back to check on Jones in the patrol car, the officer notices a gun in the back seat that he hadn't noticed before, and so he then charges Jones with illegal possession of a firearm. And when it goes to the district court, Jones files a motion to suppress the gun evidence. This is a big deal, right? If you're being charged with illegal possession of a firearm without the gun, there's essentially no grounds for a conviction. So this is a big deal. The district court reluctantly, and I use quotations there, reluctantly grants the motion, meaning the gun cannot be in play in a trial. And the district court reasons that it essentially states that the Fourth Amendment prohibits cops from conducting Terry stops to investigate already completed misdemeanors. And I'll get into that more in a bit, but that was the court's conclusion. And now I'll dive into some of the legal context. For listeners who aren't so familiar with the Fourth Amendment, I'll give you a little bit of an overview. So when cops stop you in a car to ask you questions, even if it's really briefly, that's a seizure. And the Fourth Amendment protects people from unreasonable searches and seizures. And the default rule is that if a cop is going to stop you and disrupt your life because they think you may be involved in something, they need probable cause to do that. But there are limited exceptions that the Supreme Court has come up with over the years. And one of those that's at play here is from a case from the 1960s called Terry v. Ohio. And Terry v. Ohio says that officers can stop a person and ask them questions without probable cause if they at least have, quote, a specific and articulable facts, end quote, that supports a reasonable suspicion that the person is currently engaged in a crime or is about to commit a crime. This is known as a Terry stop, and the rationale here is to balance the government's interest in preventing crime with an individual's privacy interest. And so in that context, the specific issue here, as I previously mentioned, was whether a cop can conduct a Terry stop to investigate not ongoing or imminent crimes, but past crimes, and specifically past misdemeanors. And what the Sixth Circuit did here was it reversed the district court and said that the district court got it wrong. And it held that there is no bright line rule one way or another when it comes to whether the Fourth Amendment prohibits cops from stopping people to investigate completed non-felonies. And it reasoned that the touchstone of the Fourth Amendment is reasonableness. And that's a squishy standard, and it requires a balance of public safety and personal liberty, and it's really going to depend on each case's specific facts and circumstances. And it said that there's no per se rule against investigating a certain class of crime because that offers no help in deciding whether seizures are reasonable. And it relied on a Supreme Court case from the 1980s, a decision written by Justice O'Connor that also coincidentally came out of Kentucky and the Sixth Circuit, that held that there is no bright line rule as to whether a Terry stop to investigate a past felony is per se unconstitutional or constitutional, but rather the standard is whether there is a reasonable suspicion grounded in specific and articulable facts that the person was involved in or was in connection with the completed felony.
So, Tatiana, did the district court just kind of blow the analysis, or did it have a reason to think that there was more of a bright line rule?
Yeah, so the district court recognized that the Sixth Circuit has previously spoken about this rule, but it said that, but it recognized that it had only done so in dicta in two cases, and in one case that was not precedential, in other words, not binding on future cases. And those cases are the dicta. The ones that were discussed in dicta were Roberts and Gaddis. They're from 1993 and 2004, and they were both about Terry stops for DUIs. And in Roberts, the court found that a cop can stop a car without probable cause, but with reasonable suspicion that the driver is driving drunk. But in Roberts, the court distinguished the case from Hensley, the Supreme Court case, because the crime in Roberts was ongoing. But importantly, in both of the cases that came before this one, the court really inaccurately interpreted Hensley. Hensley said that there's no bar one way or another when it comes to investigating past crimes, but it left the door open as to whether police can police can stop people for investigating past misdemeanors. It explicitly left that open. The Sixth Circuit in these other cases misinterpreted that, said that that Hensley definitively said that you cannot do so. So in these prior cases, it was dicta, and the Sixth Circuit got it wrong. But the district court went along with these cases with the reasoning that, well, it's all we have on the issue, and so we're just going to go with it.
Josh, I have a philosophical question for you, which is, how do we know when a holding is mere dicta and not the actual holding that should be followed?
Yeah, I mean, it's not always clear. That's kind of the rub of this because, generally the rule is that is it essential for a conclusion ultimately drawn by the court in a given case? If it's not essential to the reasoning that got to the conclusion, then it's usually not. It's considered dicta. If it is essential, then it's considered reasoning, and it's part of the kind of the court's holding in the case, which binds future decisions. And I think that's. This is a tough case. This might be a case where bad facts make bad laws, the saying goes, because you kind of feel for both the officers, you feel for the court here trying to make the decision. From the officer level, how is an officer to know exactly what's a felony and what's not when, as the court points out, that's a fluid standard? There's no clear legal definition, contrary to what many people kind of in the public might think, between a felony and a misdemeanor. Everybody knows there's this kind of rough rule, right, that a 1 year in jail or more is a felony, but that doesn't always hold true. And the court in this case points that out. But on the other hand, we do expect officers to know the law. Kentucky has a right to define the seriousness of a crime in their state. And if they decide that a particular crime is not that serious, then perhaps the officer should know that. And the federal courts should allow a state to make that determination that this is not serious. In fact, we can think of all sorts of crimes that might be more serious in some states than others, maybe more serious in a busy, crowded urban area and not serious in a rural part of the state or part of the country. So, the felony and misdemeanor distinction here is really tough. And then it's, as we talked about, I think it's also tough for courts to figure out, to kind of apply this balancing test, in a way that is consistent, as the fact that the prior Sixth Circuit decisions on this case make clear. Courts come out different ways, at some point, even though you want to be realistic, you also want to have a rule that people know and that people can follow and that future courts can follow. So, I think this is just a really, really difficult case. And the bad facts here involving someone throwing cans of Sprite at their ex-girlfriend certainly does not help the need for clarity in the law in this area.
Yeah, well, and that's a frequent problem in constitutional law, right? That the courts are very reluctant to draw hard lines because we're talking about very fundamental rights and situations that can come, for policy reasons or common sense reasons, can come out differently based on different facts. And I think that that's really what the Fourth Amendment jurisprudence has been about, is about, trying to do these are always hard questions, and it really depends on the facts in the case. And in Hensley, the court went on to lay out factors that matter and to try to guide courts in the future to make these determinations. And a lot of them are, these factors don't, as the courts have said, that they don't rely on the classification of the crime or anything like that, but rather it's things like, would a stop here promote crime prevention? Would it protect safety? What's the police's interest in solving this crime and bringing this suspect to justice? And would a stop, or would prohibiting a stop unnecessarily hinder an investigation or allow someone to flee? And so these are kind of almost like future-looking factors, right? Like, what's the level of danger if the police don't do anything? And as you mentioned, Josh, this court did explain that sometimes the classification of of crimes, misdemeanor felonies, are kind of arbitrary or are really diverse among states. Like, there are some states that have 5 categories of crimes. There are some states that, for example, in Kentucky itself, the court explains that it's a misdemeanor to assault someone, as it was here, but it's a felony to cash a check from an insolvent bank. And so, yes, the legislature has made these calls, but sometimes when it comes to getting the bad guys off the streets, and sometimes it may not be the determinative factor. It shouldn't be the determinative factor. And I think that's really what the court is getting at, that these issues are more complicated when you're on the ground, and every story is going to be different, and the threat levels to the society is going to be different in each case. And I will point out that the Sixth Circuit here went along with how other circuits have interpreted Hensley, specifically the Eighth, Ninth, and Tenth Circuits. All these circuits take the facts and circumstances approach rather than draw a bright line or rigid rule when considering the misdemeanor side of the problem. And I think that that's the correct approach under Hensley. And so I think if the Sixth Circuit had gone the other way and drawn a bright line, it would be questionable under Hensley. So I feel that the court got it right here on the law. And as to these facts, I mean, the court did find that there was reasonable suspicion for the stop to justify it. And I mean, it was everything matched up, right? Like everything matched up with what the witness said, the car, the soap, the cans on the lawn. And the fact that he came back, that the suspect came back to her property really heightens that like future harm aspect of the justification for the stop. And she had predicted that he was going to do this. So I think that on the facts too, I think the court got it right.
Okay. And Josh, unless you have anything else, let's move on to the Ninth Circuit. And our final case.
Yeah, so our final case is Brown versus Stored Value Cards Inc., doing this business called Numi. And what the case involves is this business called Numi, they market their services to jails across the country. It's a private company, and what they do is they say, hey, don't worry about holding on to prisoners' possessions and cash and all sorts of things they may have been arrested with. Let us do it. We'll take care of all the paperwork. We'll keep it safe, and we'll provide a little credit card or gift card, kind of, if you've ever seen like a Visa gift card, I think it's something like that, to the prisoner upon release. And in fact, when they market these services, they actually sweeten the deal and say, in fact, we'll do all of this at no charge to the jail. We'll do this completely free. You just have to let us charge fees from these card users. And sure enough, that's what happened in this case. Danica Brown was arrested after a protest. She was protesting, I think ironically enough, the shooting in Ferguson of Michael Brown. And I say ironically because as further investigation has revealed, fines and fees have become a kind of huge talking point after it was revealed that the government of Ferguson was initiating all these confrontations with Ferguson citizens over essentially 25% of Ferguson's budget being funded through fines and fees and needing to keep those numbers up. Anyway, that's a little bit of an aside. So Danica Brown is arrested after protesting the shooting of Michael Brown and the ultimate non-conviction of the officer who shot him. She, after her arrest, she had just over $30 in cash confiscated from her. When she was released, she was given a card with the cash on it. And she was not, well, the court points out that prisoners, when they're given the card, they're not given a choice. They have to take this card to get this cash back. And although they are informed that there will be fees, including, for example, a $5.95 monthly service fee for money that continues to sit on the card, or a ATM fee if they withdraw from certain ATMs. There are some ATMs they can withdraw money from for free, but the card doesn't tell you which ATMs there are or are included in that plan. And actually, the list that was provided separately was out of date and didn't include all the right ATMs. So Brown was provided with this card, and ultimately the company withdrew from the $30. I think something like a third of the value of the card was missing by the time that Danica tried to use it because of these fees. So she files suit, a class action actually, in federal court, and brings some state law claims, some federal claims, as well as a constitutional takings claims. The state and federal claims involve a lot of Consumer Protection Act sort of claims. So in Oregon law and under federal law, there are various regulations that apply to cards, whether it be gift cards or credit cards or whatever, that are provided to people and are marketed to the public. The district court granted summary judgment to the company, Numi, and Brown appealed. And on appeal, three issues were really at stake. The first issue was whether or not the state law claims could go forward because the card was actually whether it was actually had been marketed to the public. And the court, looking at it, actually looks into the facts and says, look, even though this is not marketing in a kind of traditional, we're trying to get you to buy our services sense, this is marketing to the jails. This company clearly marketed its services to the jails, to the other people that contracted to use this service. So there was marketing involved. And there was also a kind of indirect marketing, which is covered under the relevant statutes, because the marketing is being, the card is being given and information is being given to the ultimate consumer, which is I guess, released prisoner in this case. So you have, you do have some marketing. And so the court very rightly goes, no, to say there isn't marketing would be kind of a technical or technicality. Really, this was being marketed when you look at the facts in this case. Now, the second thing that was considered was during discovery in the case, the Brown actually discovered that there was additional evidence that could have supported her claims, and the district court denied, without any opinion, just denied her ability to amend the complaint. Something that is complaint amendments are done pretty liberally, and especially when there's good reason, such as new evidence discovered, to amend a complaint. And the court very quickly says, that was an abuse of discretion. You can't just prevent a defendant or a plaintiff from amending their complaint when they have a very good reason for doing so, and there's no evidence that they were trying to delay proceedings or have any other sort of illicit motive in asking to amend a complaint. And then finally, they actually consider a constitutional takings claim. And again, the court says there should have been more discovery on this claim, and it shouldn't have been dismissed. Just to kind of rewind a bit, what happened was that the government had actually moved or not the government, excuse me, NUMMI, the contractor, had actually moved for summary judgment before the completion of discovery, which they're allowed to do. But of course, the plaintiff can oppose that and say, no, there's more facts that I need, or I would like to go to trial if there's an actual dispute of material fact. That's the relevant standard. And on the takings claim, the court basically says, no, there was a takings claim stated because, providing a card with fees is not the same as actually giving the full cash back. And notably, the big difference that the court points out is that providing a card where the value of the card depreciates over time is not the equivalent of giving someone's cash back. Someone's cash doesn't start disappearing in their pockets as they hold on to it over time. But with this card, if you hold on to the card and don't withdraw the money the right way at the right time, you will start losing the value of your property. And so the court said that potentially is a takings claim, that the plaintiff should be given the opportunity to prove that takings claim. So I think on the whole, a very engaged decision. The court doesn't buy the very formalist and technical distinctions that the company here tries to draw. And I think it's also worth pointing out that the court seems extremely concerned about the reality kind of behind the curtain here. They seem very concerned about the fact that this is a relatively simple function, holding on to cash until someone's released and giving it back to them, that has somehow been complicated by companies that have a profit incentive that offer these kind of too good to be true deals to local governments or to these jail providers about, hey, we'll do these services for free. Just let us penalize the people, who are in the jail system instead of you paying us to provide these services. And the court's concerned about just the interaction of the monetary incentives here and how that seems to have both complicated and a relatively simple process, but also it could be kind of impacting the property rights of released prisoners across the country.
Tatiana?
Yeah, Josh. So I noticed that in this case, and this is important for the takings claim, the court does not really decide whether the card company here is a state actor, although they clearly are doing a state function, which is a problem. It can be a problem for reasons that you just stated. But the court also explains how different counties maybe delegate this function. And I was curious to hear your thoughts on whether you thought these other options, which I'll explain, are maybe more constitutional or less constitutional. For example, the counties of Napa County and Broward County, which are traditionally, I think, more wealthy counties, they can afford to subsidize the costs of these cards rather than pass the costs along to the released prisoners. I personally don't find that would create a takings problem like we have in this case. Do you think that it's is that a better way? Is that a more constitutional way of delegating the problem?
Just to clarify quickly, so those counties, when debit cards are given to released inmates, there are no fees on those debit cards versus what we have here in this case, where there are a bunch of hidden fees.
Yeah, I mean, clearly that would solve this problem where, at least in those cases, it sounds to me, and I haven't looked into them, but it sounds based on what you're describing, like in those cases, the government entities are paying those fees, essentially. And that would be okay, because in fact, you could argue that's actually how this process should work. As far at IJ, we've looked into this because we litigate across the country claims involving prosecutors or judges that have unconstitutional profit motives or financial incentives to do to make decisions against defendants. That's not constitutional. The Supreme Court has been clear about that, especially as regards judges. It is not constitutional for a judge, the minute you step into the courtroom, to have a financial incentive to convict you. The judge has to be a neutral government officer. And I think that, bringing it back to what those counties are doing, it gets rid of that kind of, it breaks the chain because, yes, you're using a privatized system, but the privatized system is basically it's being paid out of the general fund. It's the same as if, they were just paying an employee to do that action, like a city employee, only instead of a city employee who works under the HR department of the jail or of the municipality, you have an employee who works kind of through an outside contractor. So, in those cases, that is clearly not a taking. It's being funded kind of the right way. And there's also no sort of illicit kind of profiteering going on in the background. Now, compare that to the cases that I mentioned before, that across the country where you have individual, for example, private prosecutors who are being paid as outside contractors and then are ultimately paid out of the proceeds of a prosecution. In other words, they force the defendants to pay the hourly rates of the prosecutor that just prosecuted them. That's a world away, because in that case, this private contractor, much like what's going on here, the private contractor is not getting paid by the government as if it were an employee. It is getting paid out of the people that it prosecutes, or here out of the people that it's taking these fees from, that it provided the card to.
Yeah, and I noticed that in this case, the circuit court remanded to consider the reasonableness of the maintenance fee of this $5.95 fee, and you mentioned that it's essentially like a storage fee by a bank. And it's that I thought, I mean, I understand this company needs to make money and the court, we all acknowledge that. But isn't it odd that it's almost like it's a savings bank, charging you for keeping your money in the bank? And I could just say, I mean, we all know that bank in the real world would never have customers. In fact, the banks pay you via interest to do business with them. And I think it's really telling here that these released prisoners can't choose this option. And I thought it's a crazy business model. It almost is the reverse of how a classic bank governs.
Yeah, I mean, and it'll be interesting to see how that is litigated ultimately, because there is very interesting precedent, as the court alludes to here, about if it is a fee for a service, there are rules about what a reasonable fee is. There are rules on like how much that can cost and how to do that analysis. It's a set of in fact, it's the precedent in that regard could actually probably be better developed, because we're seeing this across the country where fees are being slapped onto things like speeding tickets, where I think California is a good example. At one point, if you got a $100 speeding ticket, it morphed into $490 after fees were added. And some of the fees included fees for like the California, I believe there was like a sewage fund or something like that, something going to sewers. I mean, they were essentially using them as taxes, but calling them fees. And there's very strong precedent, as the court mentions here, that a fee has to be related for a particular service that's provided. You can't just call anything a fee and say, oh, it's a fee. So it'll be really interesting to see how this is ultimately decided once it's on remand.
Okay, that concludes the show. Thanks for joining us. We hope you tune in next time. Until then, this is John Ross from the Institute for Justice, wishing that you will stay engaged.